So hi, everyone. Thanks again for joining us today, and thank you, Michele, for speaking. It's great to have you. So Michele Follows is a professional executor, trustee, and attorney for property and personal care. She's a chartered professional accountant, a chartered accountant, a certified public accountant in Illinois, and a certified executor advisor. She has also recently completed the 4-year program with STEP for her certificate in Trust and Estimate Administration, or CETA. As an estate simplifier, Michele is excited about being able to offer affordable estate administration and estate accounting services to more people, and has teamed up with various estate lawyers, accountants, and financial planners to offer a full range of services depending on each individual's situation. Every person and every estate is unique, and Michele is passionate about being able to simplify the process and make it affordable for everyone. Thanks again for presenting today, Michele, and good luck with your presentation.
Well, thank you. And a warm welcome to everyone. Thank you for joining me this afternoon. As Alex just said, my name is Michele Follows, and I'm an estate simplifier. I hold people's hands through some of the darkest moments in their lives when someone close to them has passed, and they have to deal with all of the items that they've left behind. So the personal items, the tax work, the paperwork, the legal stuff, all the stuff. So I'm a professional executor, trustee, and attorney for property and personal care. And I help people to navigate the complex world of estates by either holding their hand through the process and doing most of the legwork for them, or I can take over as an estate trustee or executor. They're both interchangeable, or the attorney myself. So today's topic is, are you leaving a legacy or landmine? So I want to talk to you about some of the items about estates that people just don't know, and it's important for them to know. So we're going to cover 3 topics today. We're going to talk about estate law, we're going to talk about accounting and tax, and we're going to talk about some executor administration issues. So let's back up just a little bit and let's set some groundwork. There are 3 main documents that are involved in the estate world. One is a will, and one is a power of attorney for property, and one is a power of attorney for personal care. And it's very important that everyone has all 3 of these. So the will looks after someone's items once they have passed. So the power of attorney documents look after someone while they're still alive but can't look after their own affairs. So the one for property would be over property and personal finances, and the one for personal care looks after their social, looks after their medical concerns, what they're living, what they're eating, that type of thing. So the power of attorney document up until the point of death, and at the point of death, it becomes the will. So let me share some stats with you. Not only do 62% of the people in Canada not have wills, another 12% have invalid wills, and they don't reflect their current financial situation or wishes. So that's 74% in all. Think about that. That would be over 12 million Canadians. So let's figure out why does this happen? So people don't have wills. I've named a whole bunch of them on this screen, but I'm going to focus on the last 3. So people try to wait for the perfect time to do it. They don't realize that they really should be updating their wills regularly, every 2 to 3 years max. Some people believe it's too costly to do their wills, and they haven't really looked into it. They just have this astronomical amount in their minds. And the last one is the one that I want to focus on right now, which is that they inadvertently don't have a will. They think that they have a will, and if you ask them, they have a will. But let's say, let me just finish that sentence. Marriage nullifies the current will. So let's say you are a couple, you're on to your 2nd marriage, and you think, oh, I have my will from before, so I'm just going to use that. You have your will from before, I'm just going to use that. You get married. Well, both of those wills are null and void, and technically you are dying intestate. So you have to refresh your wills after your marriage. So that's why a lot of people don't have wills. So big deal. A lot of people don't have wills. What is the big deal? So I've listed a bunch of here. And the number one reason, or the number one problem that it is that no one is appointed as your executor. The courts have already decided what's happening to your assets, so that's not a big deal. But no one can actually look after it. And the banks won't talk to you, the investment companies won't talk to you, the real estate people won't talk to you, no one will provide you with any current information. You're not the executor, they won't talk to you. So someone has to step up, hire a lawyer, pay the probate fees, or apply to the courts to get this, which would be a certificate of appointment of a state trustee without a will, which is, again, I'm just going to call it probate for easier terms. Pay for all of this themselves, and then they also have to have all the beneficiaries on board. And as you know, not all families get along. So you can see it can be quite the task to get an executor appointed if you do not have a will. So the last implication that I had mentioned, if I go back one slide, the common spouses are not provided for. So let's talk a bit about that. If you don't have a will, common law spouses are not looked after under the current state law rules. So everyone knows in the tax world that your common law, for tax purposes, the CRA puts you together fairly quickly. But this isn't true under a state law. So common law spouses are not recognized. So if you don't have a will, and we go back to that preset formula that we talked about, your common law spouse will not be looked after. And it doesn't matter how many years you've been along. Eventually they might follow your family law rules, but they're not going to get looked after. So let me give you an example that I'm working on in the state court right now. So the couple, they're in their late 40s, they're onto their second relationship. The husband-to-be moves in to the townhouse. They start paying all the expenses together, and the wife, the female, passes away. And it happens to be, sadly, on the day that they were supposed to get married. It was delayed because of COVID, but regardless. And now the fiance is left with, she passed without a will, so he's not looked after under common law rules. That townhouse goes to her 20-year-old daughter, and so not only does he not have a fiance anymore, he doesn't have a house anymore. He's out of house now. So it's important that you have a will even if you're not married. So let's talk about probate. Everyone likes to talk about probate. So let me just explain for everyone what probate is. Probate is a process whereby the Superior Court of Ontario ratifies the current will that you have and says, yes, this is the final one that we're going to use, and then acknowledges the executor that you have in that will. So in Ontario, there's no suppository for the regular will, to register your wills. So there's no one to say that this is the final will that you have. So let's say I have the will, and I go up to the bank, and I say, here, this will says that I'm the executor, and the bank gives me everything in your bank account, and then someone comes up 2 weeks later with another version of the will that's got a more current date and says, no, I'm the executor. The bank has already given me the money. So now the bank has to come back, ask me, oh, Michelle, can you please give me back the money because it belongs to you, so-and-so. So to bypass this whole process, they do what they call the probate application. And it's actually called a certificate of estate appointment with a will. And so there's longer names to these. And so what this probate document, no one will talk to you unless you have this probate document. Now to add to this, more recently, the authorities now come down, now they've given to the Ministry of Finance. It used to be the Attorney General, and they have introduced the Estate Information Return. And this is just basically a return that details what was put into the probate application, saying what items add to what, and it trues up what we've presented in the probate application. But now they are now auditing these returns, and they can apply huge fines and possibly jail terms for any fraud and errors and misinformation that's been given. They allow themselves 4 years to do this audit, and they don't provide a clearance certificate. So now think about some of your tax rules. Everyone talks about the executor year. I know some of the charity rules are trying to get everything settled in less than that 4-year period, but yet you're supposed to wait the 4 years for the audit to complete. So the left hand is really talking to the right hand. So I'm just flagging it. Watch for your audits and your timelines, and make sure that you're aware of what's going on with these probate and estate information audits. So now, even though probate taxes are only 1.5% of the value of the estate, no one really wants to pay. So there's a lot of ways around them. You can do insurance products, designated beneficiaries, but the one that I really want to talk to you today about for you guys is the second will. So we just talked about probate. When we're ratifying probate, you have to put everything that's in that will, all the person's assets has to go into that probate application. But not everyone needs a third-party ratification. Like, for example, your shares, you own them. You don't need to tell someone that you're going to release your shares to your executor. So the assets that don't need to be probated can be put into a second will. And that second will does not have to, any items in that second will do not have to be included in the probate application. So that takes off the pressure of having to do evaluation of your business for that probate. And then you're obviously not paying unnecessary probate taxes on that. And then, as you know, probate are public documents. So you now have more privacy if you put everything into a second will. So let's move on to non-Ontario property. So I flagged it as non-Ontario because it's anything outside of Ontario, or foreign, which would be the US stuff. So if you have assets outside of Ontario, an Ontario drafted will may or may not cover these assets. It depends on where they are. So it's best to find out now and before it's too late. So as a rule, you want to have a separate will and a separate power of attorney in each jurisdiction that you have. So if you have a property in Florida, you want a will in Florida, one in California, one in California, and use lawyers from each of those areas to do those wills so you have the proper rules. And just be aware, because a lot of times people don't even know that that person might have a property in Florida when you're doing their I'm going to say their taxes, because you guys mentioned CPAs, but you understand what I'm trying to say. So now let's talk about foreign executors or attorneys. So now you got a problem not only for assets, but you've got your kids that have now moved down to the States, and they're your executors or your attorneys. So you got the problem of the U.S. not accepting any executors from foreign jurisdiction, and then you also have the Canadian side. I've listed the 4 problems here on the slides. The Canadian courts may not allow for a foreign executor in the first place when you're applying for the probate application. We'll talk about it later, but a foreign executor will result in a foreign estate, and so you might have foreign tax implications from this. Because you got someone from the U.S. that are pulling assets outside of Canada, the courts may require a bond to be issued. And then you've also have the problem that Canadian investment managers will not take any instructions from a foreign person. So there's a lot of issues. At least be aware of them and make sure that you take these into account if you happen to appoint foreign executors or attorneys. So let's jump into accounting and tax. Because I'm speaking to a CPA audience here, I am not going to go into much detail. I'm just going to give you an overview of things you should be aware of for your client. Joint property and gifts. So, as you know, many people say, friends and family advise everyone, get a joint bank account, and that way you don't have to worry about probate and all of that stuff. So people know that, tax-savvy people know that changes in ownership and title of assets usually results in an actual disposition and could result in capital gains and all of that stuff. So, so that's one of the problems with that. Joint ownership can cause issue as to who has the legal right to this property. I have heard countless stories of, Jane having a joint account with mom and thinks that this money is hers, and the money has been gifted to her. So because mom loves her best, right? So there's an issue there as to who has the legal right. It may not, in fact, actually avoid the probate taxes, because in the probate tax application, they say if you have a joint property, who has beneficial ownership? If it is mom's, and it was always mom's, and she put the money in there, it's mom's. And so you have to pay probate on it anyway. And that's one of the areas that they're highly audited. And then the last one is a resulting trust. So Jane is on the name with the account with mom, and Jane says the money is hers, but really it belongs to all of the beneficiaries. It's a resulting trust that she's created on behalf of everyone else, and it has to be split. And it may be considered an early gift. She's just been paid ahead of time her portion of the estate. So we talked about U.S. property, estate tax, and inheritance tax on foreign property. So let's go back to those foreign assets. You have, if a person owns a U.S. property that has a cost of more than $60,000 US, it could be estate U.S. estate tax implications. So there's lots of exemptions available, and you might fit into that exemption. But in order to get that exemption, you have to file for that exemption within 9 months of the date of death. So watch for these dates. It's really important to make sure that you do that. Otherwise, as executor, you could be liable for having to pay the U.S. estate tax unnecessarily. And each country is different, so know the rules of each country. So I'm just flagging that for you. We talked about foreign executors. There's residence issues as the estate is taxed in the country where the executor resides. It could result in double taxation if they don't have any treaties. So you need to make sure that you know the rules for each one of these. And donations. We're not going to get into all the different, oh, sorry, the next slide. We're on the next slide. So the last area I want to get into in some detail is business assets and estate planning. So we talked about having a second will to bypass probate, but now I want to explicitly explain what happens. So as the executor, I take over, you've passed, I take over your shares of your business assets. So now what do I do with these shares? Have you given me any instructions as to what I should do with these shares? So the first thing I'm going to do is I'm going to fire the governor to become a director of that company, because I need to do either, I need to sell it, do I need to, wind it down, or transfer it to someone else? I need to be a director to be able to do this. So your first step is you need a shareholder agreement. If you've got a shareholder agreement in place, I know what my marching orders are and I can follow through with it. If not, your 65-year-old, let's say I'm your 65-year-old spouse, I could become your new business partner. And, we both know what that can lead to. So that's not exactly your ideal situation. So there's more than just having, a will, a second will. Make sure you have all your documents in place and your shareholder agreements are up to date. The second area that we run into a lot is that taxes on the final return versus the designated beneficiaries. A lot of people are so worried about these probate taxes that they put everything into designated beneficiaries, so it bypasses the estate. Oh, good, we don't have to pay probate, but they haven't left any money in the estate or for the final taxes, because let's think of an RSP. RSPs go straight to the designated beneficiary, but they're taxed on the final tax return. So be aware of the mismatch of the money and the tax liability. I'm not going to go into the donations and other tax planning opportunities. Those are for estate planners. Just want to flag them for you, that they're great ways to decrease taxes, benefit lots of people, and you should be looking into, you should have your clients look into that. All right, so now we're into the area where I'm most comfortable. The other areas are your specialties for taxes, and the lawyers, the estate lawyers. I know the rules, but I am just more the air traffic control. So we talked about how an estate trustee is a new term for executor, so I can use those interchangeably. And an estate trustee has been given the fiduciary responsibility of managing someone's affairs after they have passed. They're expected to handle all of the estate's assets and liabilities with due care and in a responsible manner, regardless of their education and background. So I'm not sure if some of you have been appointed as executors or taken on that role. It can be quite onerous. Some of you might even be executors and you don't even know it, because people have appointed you in the will, and that might come up after. But my job here is just to make sure that you're aware that there are special rules that govern what you can and cannot do, what investments you can get into, how much compensation you can take, a bunch of different rules. Be aware of them and make sure that you follow them. I'm working on a case right now where someone's been appointed to the Law Society of Ontario because they didn't, was a lawyer that didn't do the estate administration properly. So, what are the risks of being an executor? If it is determined that certain losses of the estate, such as late filing penalties, the sale of assets that are well below fair market value, or those, U.S. estate tax that we just talked about, if they could have been prevented, the executor could be accused of fraud or negligence, and they are 100% liable for that. So not only do they have to repay any compensation that they may have taken, that they will have to use their personal funds if it's higher than that. If you distribute the estate prematurely and their remaining liabilities are taxes, you can get the tax clearance certificate. You could maybe have to personally compensate the beneficiaries for those errors. We talked about the estate information return. There are punitive or possible imprisonment for errors. If you have a business, executors will be responsible for running it. That is a big responsibility. And tax creditor and other legal implications become their responsibility. So to mitigate some of these risks, I'm just letting you know that there is such a thing as executor insurance out there that is only available once you become an executor, and it can help you look after some of the items, including that 4-year window for the audit. It will help you to cover that in case you get audited after you've done the dispute. So when do the executor duties begin? There's a lot of talk about probate. When does the actual authority happen? The authority happens in the will. So if there's a will and you've been legally appointed as executor, technically that is when you take authority. So that would be immediately on death. The probate application sometimes doesn't need to happen. So it's just for a third-party ratification. You don't have to wait for that, and it's important that you start right away, actually. What if you don't want to be the executor? So sometimes you're not in the right place at the right time, you've got some health issues, you've got family issues, or I just scared you now and you don't want to become an executor. You don't have to. You never have to be. You can always renounce. But I will warn you that if you start the process, you have to continue. It's called intermittently. So if you put on the persona, you do the funeral, you start going along the way, and then you go afterwards, oh, I really don't have time to do this executive. It's too much work. It's overwhelming. You can't stop. You'll have to get a court order to stop. So you can renounce anytime, but once you start, you have to finish. So don't start if you're going to not take it on. So can I get assistance? The executor's job is to make sure that the estate gets liquidated, not necessarily to do all the work themselves. And actually, the estate law is actually trying to encourage people to make sure when they're doing their due diligence to follow professionals. So get an estate lawyer, a tax preparer such as yourselves, an investment advisor for the investments. That's one requirement. You do have to invest the funds as a prudent investor would. Or, as a shameless plug, I'm going to suggest that you get a professional executor. I can do as much as little as you want and let you make all the decisions and allow you to get the job done more efficiently. There are other resources online. There's checklists, other information, the funeral homes. They also offer an aftercare program. They can help you do some of the initial paperwork, such as the CPP, death benefit, and that type of thing. So there's a lot of resources out there for you. So what happens if the estate is bankrupt, or if you fear that it might be bankrupt? Stop. Get professional advice. And that means don't even do the funeral, because if you do a more lavish funeral than is allowed, you might have to pay for it, personally liable. You'd be personally liable for paying for that difference. That includes the tombstone, any of that sort. So stop, get professional advice, the CPP may cover some of that. Death benefits, it might not. It depends on if they paid CPP in the past, but that's as much as I can tell you about that one. So what happens if an executor declines the position? So you've renounced. What happens to the estate? What would happen is someone has to volunteer to be it, and all the beneficiaries have to agree. If that's not the case, then a public trustee and guardian could jump in and seize the assets. So that's not the scenario we want. So you want to have the more backups, the better. So it's always advice to have a professional trustee as your last resort. And John just stepping in for one of the trust companies that was the last resort and renounced. So I'm being appointed as the executor by the courts. But, you know, at least if you've got more than one option, it's always better. All right, my last slide, compensation for executors. The Ontario statute allows for 5% of the value of the estate to be paid as compensation for the executor. it's a general rule of thumb, so it's actually 2.5% of items going in and 2.5% of items going out to allow for any gains that might be on those assets. So it's a lot more tricky if you are a professional and you are also the executor, because you have to split out your work. You can the state will compensate you for, let's say, preparing the tax returns, but any work that you do as the executor would fall under that 5% rule. So you have to make sure that those two areas of work are completely separate, and that you don't double dip, and that you have no conflict of interest when you're doing so. So also be aware that there is such a thing as pre-taking in a will. So if you have been appointed as an executor from way back, and there is no pre-taking specifically allowed in the will, then you have to wait until the estate has been distributed to the beneficiaries. At that point in time is when you would get compensated. So 2 or 3 years after, if that's the case. So if you are going to be written in someone's will currently, ask them to put in the fact that you can pay yourself on a monthly basis or more regular basis. And please remember that executor fees are income. And so either business income and you put HST, or personal income and you would go through the payroll system. So the law stipulates that every executor is entitled to compensation. So it would cost the estate the same or less to hire a professional executor as it would to hire a family member. So just keep that in mind when you're trying to see whether you're going to hire professionals or not. So that's it for today. I thank you for your time. I am putting a disclaimer in because I am not putting on a legal hat or a tax hat. I am just an executor. So please see those consultants when you need some specific advice. So I hope that this has been helpful to you. There's so much more that I would have liked to have said to you, but it's so much into a 30-minute presentation. If you need any clarifications on these points, my numbers are below. Please contact me. I'd be happy to help. As you said, I can be a professional executor. I can do any of the legwork for you. I also do estate accounting, is what they call it, or trust accounting, to get the documents in a court-appointed format. I also act as power of attorney for property or personal care, all of those items. And finally, this has been set up as a lunch and learn type of a seminar. So if you would like to collaborate and present this to any of your clients, you can do the piece that relates to your practice, and I can just be your back office and get all your clients informed for information that they need to know. So let's work together and ensure that everyone leaves a legacy and not a landmine. Thank you. If there's any questions, I think I have a question.
Hi, Michelle.
Hey.
How are you?
I'm good. How are you?
That was great. Thank you so much for participating today. It was a lot of information into 30 minutes. I've seen you do it before, but that was an hour. So, so thanks for condensing.
Excellent. So is there a place where we can do questions, or how does that work?
Yeah, it's in the chat. I don't see any questions here right now, but I would suggest if you want to put your actual email address or your contact information in the chat, then people can directly click on it.
Oh, okay. So my email address?
Anything, any way, your website, just so a way that someone could contact you, so it's easily, like you can click on it easily.
Okay, I can do that. I can do that. Okay. And then Alex said that he may have taped this for me, which is awesome.
If anyone does have any questions, you can put them in the chat. We'd be happy to take them. We have a couple minutes left here.
Yeah, it's hard to know how long, hey? I probably talk too fast.
No, that's okay. No worries at all. Thank you very much for joining us. We've had a lot of really good speakers today. We have an awesome panel coming up. So it's so much different doing it. Michelle used to do our live events with us. It's so much different doing it virtually. Hey, Michelle?
Oh my, yes. Even trying to make sure that the virtual works, the registration works.
I know. Have you been doing a lot of virtual events?
I have been trying to, and I'm gearing up to do my first big one. I'm going to the STEP conference next Monday and Tuesday. So
Nice. Well, thank you for joining us today. If there's any questions, I can maybe filter them through to you afterwards. I just want to inform everyone we have a panel coming up. 4 fantastic panelists. If you don't mind, Michele, I'm just going to run through it. It'll happen on our main stage at 3:30. So we have Paul Gambino, who's a partner at Avio Fine Homes. We have Jun Shi, who's CPA CGA and accounting director at Maple Leaf Strategies. We have Hillary McGuire, CPA CA and VP of Finance at Avec Networks Inc. and Paul Tiers, who's the managing director of Wealth Stewards. So should be a really good conversation, going to be facilitated by our president, CPA and CA, or CPA CA Mark Belage. And they're going to go through just what's been happening with the pandemic from a company perspective, strategies. They're going to talk about maybe things their company was implementing or plans to implement as we reopen. So it should be good dialogue and conversation. Again, thanks so much for joining us, Michele. I hope we can catch up. I haven't seen you for a long time, so it'd be nice to catch up with you soon.
Excellent, and maybe hopefully a live session next year.
I hope so too, Michele. Thanks for joining us. And the panel again will take place on our main stage at 3:30. All right. Thanks, Michele.
Okay, bye everyone.